What's going on? I am going back to how I used to make videos, just testing this one out. I am putting 3 clips in one video, just to see how you guys like it. Anyways, I've got 3 clips, 2 Judge Shackelford, 1 Judge Gauthier, and yeah, we have 3 defendants who are on the receiving end of the FAFO. All 3 cases. Defendant's not happy, judge is going off, they're not happy. It turns into a fun video. Anyways, I'm Colin. We're cooling. Let's go.
This is 2-4-2504, the people versus Otis, Purdue.
Also, you have on behalf of probation.
Morning, Your Honor. Jeffrey Fant on behalf of Mr. Purdue. Today's time of day set for sentencing. We've had a chance to review the pre-sentence report. Same appears to be factually accurate. Obviously, I'd like to address the recommendation.
All right, go ahead.
Judge, keep in mind that this is a 2022 offense. He did attend and complete treatment court in circuit court in 23. And I would ask the court to consider allowing him to be placed on probation. Again, this is a 3-year-old offense. Prove that he's worthy of the probationary period. He's willing to. I think the issue in the interview, he understood about going to treatment, meaning inpatient. I don't think Mr. Purdue would qualify for inpatient at this point, but he would certainly have no objection to probation with even if it was like under ISP.
Are any of these, I have never, this is the law. Your first criminal offense was the year I graduated high school. And then you had one, and you probably did some time on that one. And as soon as you got out, you picked up 1, 2, 3, 4 more. 4 in 99, 4 in 2000, 2001, 2002, 2005, 7, 8, 10, 11, 11, 12, 13, 13, 14, 14, 15, 16, 18, 20, 20. I mean, I've never seen a criminal history take up the whole front page of a PSI. I've never seen that before.
They were all retail fraud, and I was going through a rough patch of life. I was substance abuse.
So let me ask this, Ms. Hat, but the problem is you didn't go to any of the AA meetings. So like when you're on bond, listen, when you're on bond conditions, right, pending sentencing, one of the things I look at when I'm determining about whether or not you're a good candidate for probation is if you comply with bond conditions. And he hasn't gone to any meetings?
I wasn't told nothing about no.
Yo, yeah, you were. We'll find the record. I guarantee I said it.
All I was told was put on a teller. The alcohol.
I promise you. I promise you. I can pull up the record because I have a little sheet here where I check off all the boxes when I arraign someone, and that would have been a requirement. But listen, Ms. Havner, he finished treatment court in 2020. Was that for this 2023 offense?
I finished in 23.
It was a 2020 offense, Judge.
So we picked up another controlled substance case in 2023.
He did.
After he finished treatment court.
Yes.
Correct. That's why I deem he's not appropriate, because he's even incurred new charges since this offense. He keeps incurring charges. So that's
And then
why-
I mean, we're not talking about a jaywalking.
Yeah, the cases are all.
Hold on.
And just so the court's aware, that 2023 case is another case that was late in being charged and it's now pending.
But it happened after he finished treatment court.
Yes, but there's no conviction associated with it, Judge. He's, I think he just got bound over in September.
Both of the cases they let me kind of had no idea of the case. Both incidents occurred. They wrote me tickets and cut me loose. I didn't go see no judge or nothing. So
they're allowed to do that now. That doesn't mean it's not a criminal offense.
He's talking about this one, which was May of 22, and the one that's pending now was in November of 23. They did not. They were in that pile that
gave me a court date.
He's got another one he just picked up in Redford in 2025. I've seen another one that's not even, I mean, Ms. Havner probably didn't put it on here because there wasn't any room, but he's got another warrant pending out of Redford in August of 2025. So just like 2 months ago.
Yes, that's how I became aware of these offenses. It was driving, I was driving.
That's not what this says. This says it was a public order crime,
No,
misdemeanor.
it was tickets. I was driving on Telegraph. I got pulled over, and that's when the OWI and the other both tickets popped up. I was driving, bringing my baby mom.
Ms. Hamner, anything else?
No, Judge, I mean, I full term to my recommendation. I do not view him as a good candidate for probation due to, you know, just non-compliance. I mean, he keeps incurring criminal charges.
Yeah, I mean, he's picked up new cases since he's been on bond here. And he's completed a treatment court program and he continues to pick up new cases. So I don't think he's probation eligible. He's got all these cases. And a controlled substance, a disorderly person, and some other public offense out of record. Those have occurred since he completed treatment court, and 2 of them are since he's been on bond here. I mean, I don't know what to say. Anything else?
I haven't caught anything on bond.
Since you've been on bond?
I haven't caught any case on bond.
Yeah, what time? You were arraigned in 2024, the first time. And in December of 2024, according to your history, you picked up a case since then.
Each bond that I have given personals, and the only thing I have received is traffic violations. I haven't caught in any cases, Your Honor. Everything that is on me now is, 2 to 3 year old cases. But since those cases, I haven't came in contact with the police only due to driving.
Anything else, Mr. Fanto?
If the court's inclined to place Mr. Purdue in custody, I'd ask for something less. He has 67 days. I'd ask for something less. Again, this is a 2022 matter.
So you have state costs of 50, a crime victim's rights fee is 75. The warrant fee and the clearance fee are being waived, statute fee. So that brings you have 125 that you owe, and those 2 are mandated by the state of Michigan. You have 70 days in jail, credit 26.
All right, that was just a quick one to wet our whistles, as they say, and we're going right into the next one. Still with Judge Shackelford, and this one's a little worse. They're gonna get gradually worse as the video goes on. So let's go.
Mr. Kazicki, I'm sorry, can you tell me that?
McLean.
All right, do I have McLean in the courtroom? McLean,
What are you still in the room now?
Miss Maribel, give me a minute. I will call your case. I'm doing my
okay.
best.
I do understand. I just heard
Yeah,
her say something. I'm sorry.
No, I'm going as quick as I can here.
I know. I'm sorry.
McLean. I don't see McLean in a break. Oh, the check-in room, trying to get him in right now. All right. Ian McLean, turn on your camera. This is 251616 SD, the people versus Ian Mclain.
Morning, Your Honor. James Guzicki on behalf of Mr. McLean. He's going to plead guilty to the reduced charge of operating while intoxicated, first offense. And Your Honor, he had a blood alcohol content of 0.168. And also we can cancel the jury trial on November 7th.
Okay, and okay, are you stipulating to that blood draw result for purposes of the plea?
Yes, Your Honor.
All right, Mr. McLean, tell me your first
Yes.
and last name.
First name Ian, I-A-N, last name's McLean, M-C-C-L-A-I-N.
All right, Mr. McLean, you understand you're being offered a plea reduction down to an operating while intoxicated first offense. That's a misdemeanor. It's punishable by up to 93 days in jail, a fine of up to $500, plus statutory costs and court costs and statutory and court costs. Do you understand that?
Yes, I do.
All right, and up to 360 hours of community service, and 6 points on your license. Understood?
Yep.
Mr. McLean, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, I did.
Did you understand your rights?
Yes.
All right, and did you give your attorney permission to sign your name on this form?
Yes, I did.
Understand that if you enter this plea, sir, that you'll be waiving the trial rights listed on that form. There will be no trial of any kind. Do you understand that?
Yes, I do.
All right, and you understand that if you're currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions?
I am not under anything of any kind of legal results at all for anything.
All right, I have to ask you all these questions. I just need to make sure you know. Sir, you understand if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation.
I am a citizen of the United States, born and raised here.
All right, sir, knowing all of that, how do you plead to the charge of operating while intoxicated first offense?
Well, I
Guilty or
entered,
not guilty? Guilty or not guilty?
I guess guilty.
Well, I don't want you to guess, I want you to know. Has anyone
wasn't-
forced you to? What's
No, I
that?
wasn't. I was intoxicated. Yes, I was. So yes, I believe I am guilty.
All right, has anyone forced you to get you to plea?
Nope.
Has anyone promised you anything other than the plea agreement to get you to plea?
Nope.
Are you pleading guilty of your own free will?
At this point, yes.
Well, what does that mean at this point? Yes. I mean, it's a yes or no question, sir. I can't accept a plea if you're not voluntarily pleading. Do you understand?
I do not feel I'm guilty. I was in a rush to go see my daughter. I forgot that I was drinking. I left my home to defuse the situation with my ex-wife. And for
Sir,
the last
were you
year,
drunk and were you driving a car on a public roadway? I mean, that's the thing, like what you're telling me, you just confessed. Basically, I mean, I don't know how you forget you're drunk, but you just told me, I don't feel I'm guilty, but I was drinking, I forgot I was drinking, and then I got in a car and drove somewhere.
no, okay, let me rephrase this. I forgot that I had drank the night before because I fell asleep in my vehicle around the corner to defuse the situation with my wife. The police officer abruptly woke me up, told me my daughter was running around naked outside, and told me to get home. I drove directly home 1 block away from my house to go make sure my daughter was all right. I was not, how do I say this?
I don't
was
know,
more
I'm
concerned
excited
about-
to hear it though. Go
I
ahead.
was more concerned about my daughter.
Oh, we're all excited to hear it, Judge. We're all excited to hear this. Let's go. Let's hear his great excuse for DUI.
Than anything else. She was 3 years old at
Sir,
the time.
but I
and she
mean,
was
there's
outside.
not an extenuating you had a 0.168. I don't know what the heck you drank the night before, but you were twice the legal limit. I mean, the police report is a 0.168. So it wasn't like you had a few beers the night before and you decided to get in the car. You were super drunk. You were twice the legal limit, according to the blood draw. But I'm not gonna take your plea. If you think you have a defense, I didn't hear one, but maybe you think you have one, you have a right to a trial. Let's go to trial next week. And you can let a jury decide if you forgetting you were drunk when you got in the car and operated a motor vehicle on a public roadway. Like, you've given me all of the elements to finding you guilty.
All right, I am guilty. I am guilty,
No,
Your Honor.
I mean, I don't understand what you're saying when you say you don't feel like you're guilty, though. What part of it doesn't feel guilty to you? I'm being honest, Mr. McLean.
I'm being
Like, I
honest.
understand.
I was abruptly woken up and I was not thinking straight. I was more concerned about my family than I was everything else at the time. I'm the only person that takes care of my children for the last 3.5 years. I am a single father and I am doing everything I can to take care of them. And yes, I was drunk, but yes, I did forget that I was drunk at the time.
Mr. Gauthier, have fun with this one. All right, we're going to jury trial.
All right.
I'll plead guilty. Yes, I was guilty. That's what it is, and that's where it stands.
I mean, what am I supposed to do with this, Mr. Gauthier?
Can I just ask one question, Your Honor?
Go ahead.
Mr. McLean, do you dispute the lab results that you had a 0.168 blood alcohol
I'm not
content?
disputing that.
Pardon?
I will plead guilty. Yes, I was. I was intoxicated at the time. Yes.
So I'm asking you, do you agree with the lab report that you had a 0.168 alcohol in your blood system?
Yes, I do. I cannot deny that.
Your Honor,
So,
that's
I mean, here's the problem, Mr. Gauthier. It's not whether or not the elements have been met, they clearly have. It's that the plea has to be knowing and voluntarily.
Right.
And he's told me he's not really willingly pleading. So the plea's not voluntary.
okay.
I mean, Mr. McLean, that's the issue. Do you understand that? I can't accept a plea of guilty if you're not willingly pleading guilty. That's what the law requires.
I don't feel I was, but yes, I was. So I don't know how to describe
Okay,
this.
we're
I don't
done.
know how to-
All right, thank you. We will see you on your jury trial on November 7th of 25 at 8:30 a.m. in person at the 23rd District Court, okay? We'll just proceed to trial. That I'm not making a determination. I'm not taking a plea if it's not voluntary. So you're all set, Mr. McLean? Your bond continues. I'll see you next week. All right.
Okay.
Thank you. Watkins, let me find that so I can get it. All right, is Mr. Watkins in here?
Oh, have fun with that one, Mr. Gauthier. That was my favorite line of the hearing. Yeah, he doesn't remember that he was drunk. I mean, he said he was asleep. He got a phone call and then he just ran out the door. I mean, that's probable. I mean, I understand that. Let me just say that I understand that if that happened, that's a defense. But here's the thing: that's not a legal defense. You're not going to sway a jury with that. You just admitted to being drunk and you were driving. I don't know. There's very few reasons why you should be behind a wheel when you're drinking. When I say very few, I mean maybe one. You know, someone's dying and you're the only person that can, drive, even though you shouldn't. You might have to drive someone. I don't know. Like this is a bad hill to die on. So I'm just gonna let it go. That was a poor excuse. I didn't remember. Okay, moving on. Last one, Judge Gauthier. Let's go.
In the courtroom and also online. And we have matter we added on today. People be Brent James Frank, file 25-7044FH. Counsel, you want to take the appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
And good afternoon, Your Honor. James Gilbert, on behalf of Mr. Frank, who's standing to my right.
Good afternoon. And this case is scheduled for jury selection and trial this coming Thursday. Talked with counsel yesterday, and counsel indicated there might perhaps be a plea-based resolution today. Do we have a plea agreement, counsel?
Yes, we do.
We also have an amending count one.
And signed misdemeanor by sobriety.
Mr. Gilbert, do you consent to the filing of an amended information?
I do have a copy in front of my client, myself, and we do consent.
And do you and your client waive the reading?
We do waive the reading.
All right, Mr. Frank, the agreement is for a misdemeanor plea here to an amended count one domestic violence second offense. All right, so do you understand? Did you read and understand the rights listed on the misdemeanor advice of rights form?
Yes, Your Honor.
And did you sign that form today?
No, yesterday, sir.
Okay. Do you have any questions for me or Mr. Gilbert about any of those rights?
No, Your Honor.
Do you understand that if you plead guilty, you will not have a trial and you'll give up all those rights that are listed?
Yes, Your Honor.
And is that what you're choosing to do today?
Yes, Your Honor.
Okay, the plea agreement provides in exchange for your plea to the amended charge of domestic violence second offense. The prosecutor will dismiss the original charge, which was the felony DV third. And there is a sentence agreement for 1 year in the county jail. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Gilbert, is that a full, fair, and accurate statement of his terms?
It is, Your Honor. Thank you.
Ms. Goodrich?
Yes.
Mr. Frank, has anybody promised you anything else?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge of domestic violence second offense?
Guilty.
Mr. Gilbert, would you assist with a factual basis?
I'd be happy to. Sir, can you state your name for the record?
Brent Frank.
And in May of this last year, were you in Sheboygan County?
Yes.
Were you at a residence with your significant other, I believe fiance?
Yes, Your Honor.
And that's Miss Yates?
Yes, Your Honor.
And at some point in time, did you, you'd consumed quite a bit of alcohol, I believe, is that correct?
Yes.
And did you end up in an altercation with her?
Yes.
At which time you physically put hands on her, were wrestling with her? Is that true?
Yes. Yes.
And she did not want to have, she didn't want to be touched in that manner or treated in that manner?
Yes.
And you agree that was without her consent?
Yes.
And again, that happened in Sheboygan County?
Yes.
And you have been in a dating relationship and living relationship with Miss Yates?
Yes.
I have no further questions, Your Honor. Thank you.
And Mr. Frank, before that incident, did you have a previous conviction for domestic violence?
Yes, Your Honor.
Okay. Mr. Gilbert, you satisfied with the factual basis?
I am, thank you.
Ms. Goodrich?
Yes.
All right. Well, Mr. Frank, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of the offense that you pled to. So I'll accept your plea. Ms. Goodrich, will the people consent to immediate sentencing?
Yes.
Mr. Gilbert?
Yeah, we also consent.
Okay. Anything you want to say on your client's behalf?
Yes, Your Honor, I did express that I would look up the jail credit for the court, and Ms. Goodrich, I believe our number is 142. That does take in consideration the amount that he did not get credit for since his sentencing in district court. And I'd also, and we agree with the 1 year for immediate sentencing. We'd ask the court possibly consider allowing Mr. Frank to participate in the programs such as trustee or the GED program, or also I believe there's a CPT program. If the court would be interested in allowing him to participate in those, he would like to participate. Thank you.
All right. Thank you, Mr. Frank. It's not required that you would say anything today, but it's certainly allowed. Is there anything you want to tell me?
Yes, Your Honor. I'm very sorry for what I've done. I know it's outside of my character to be like that, especially sober. While I'm intoxicated, I tend to take things a little too seriously and can get out of hand, and I very much apologize for that.
It's the third time you've done it. Maybe you should consider whether it is part of your character and you want to do something to change your character. But just
Third time you've done it. Yeah, it's Judge's turn to talk now. It's about to go down.
Say, well, it's not in my character when it's the third time you've done it. Sort of empty words, don't you think? I mean, you've done it 3 times at least, right? You've been convicted 3 times. Is that true?
Yes, Your Honor.
Okay, so don't tell me it's not in your character. You do it 3 times, you're convicted 3 times. It's part of who you are. Change who you are.
Yes, Your Honor.
Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. This plea agreement was done in consultation and approval of the victim who is present but does not wish to speak. I'd ask the court to follow the plea agreement and order 1 year in jail.
Mr. Frank, if I could send you to prison today, I certainly would. I'm not going to approve you for any program in the jail that would shorten your sentence even by 1 minute. If I see you again and I have a chance to send you to prison, I absolutely will. I'll sentence you to the maximum for the charge that you're pleading to, 1 year in the Sheboygan County Jail, credit for 142 days previously served. There's $50 in state costs, $75 in the crime victims assessment, $350 in court costs for $475. If you fail to make reasonable efforts to pay that by paying that when you're released, you'd be subject to contempt of court. I kind of hope you don't pay it, so then I can give you 93 days contempt. So give me a reason to give you more jail and I'll be happy to. Otherwise, if you don't want to give me a reason, you want to pay that the day you get out. You understand me?
Yes, Your Honor.
All right, you can file an appeal if you wish by filing an application to the Court of Appeals. If you want a lawyer, I'll give you one, but you have to ask me within 6 months. We're going to give you a piece of paper explaining that appellate process and ask you to sign 1 copy or initial 1 copy. So we have a record we gave it to you. And the other one is fill out if you want to take an appeal. I have not really dealt with you in the past, Mr. Frank. I will remember who you are. And every time I get a chance to lock you up, I will do so. Good luck to you.
Oh, Your Honor, is the no kind on the victim asking in the hallway? I think he's asked the prosecutors, no contact with him.
He is not on, now that sentence has been imposed, he is not on bond and he's not on probation with me, so there are no conditions.
Thank you very much.
All right, we'll stand.
All right. I love that. I love that stern warning. And Judge Gauthier doesn't mess around. He's not going to forget this guy. Yeah, if I see you again, I'm going to find a reason to put you in jail. Don't come in front of me again. Get your shit together. I love that. I think more judges need to take that stance, especially after the video last night with the guy that had 6 DUIs and he didn't even get jail time. Yeah, he had a different judge speech, but this one, I feel like this one hit home a little harder. So yeah, don't pay your court cost. Let them put you in jail. Anyways, that's all I got. Hopefully you guys enjoyed the video. My old school way of doing videos. Hit that like button if you haven't done it already and you enjoyed it. Subscribe, do all those fun things. Leave a comment, hype. I'm going to get better at responding to comments. So leave a comment and hopefully I respond to it. Anyways, that's it. That's all I got. Till next time. Bye.
Sure.